Ladies and gentlemen, we now turn our attention to the next panel discussion, one that takes us from strategy to implementation and from principle to practice, enforcing the role of law. We'll examine how international legal frameworks, particularly the work of UNCITRAL and its contribution to international dispute resolution and future direction. So please join me in welcoming all the speakers and the moderator for this session. As you can see, their names on the screens. Welcome. I pass the mic to you. Please, a big round of applause, ladies and gentlemen. Thank you.
Your Excellencies, ladies and gentlemen, friends, welcome, assalamu alaikum. You're hearing a lot of interference. Sorry, I don't know if that's me or that's the system. If I sit still, hopefully that won't happen. I'm very, very pleased to welcome to the stage His Excellency Mr. Abdulaziz Al Dohaim, Assistant Minister of Commerce in the Kingdom of Saudi Arabia, Anna Juvan-Brett, the Secretary of UNCITRAL, and Audley Shepherd, President-elect of ICA. Ladies and gentlemen, in 1966, two major world events happened. Firstly, most significantly, England won the FIFA World Cup. Secondly, but also of significance, on the 17th of December 1966, the UN General Assembly established UNCITRAL, the United Nations Commission on International Trade Law, the single most significant private law entity internationally and certainly within the UN. This is a celebration. I am told it is not a celebration of England's FIFA triumph, although in England, for lack of other trophies, we are still celebrating it. We are celebrating instead UNCITRAL and its 60 years in a world of increasing economic interdependence, where it's critically important to develop and maintain a robust cross-border legal framework, but also in a world under pressure in terms of what many of us had assumed was a settled legal order post-World War II. We are going to explore the foundation and the activity of UNCITRAL with the expert panel that you have. You'll be aware that UNCITRAL, as Anna has already told us earlier today, covers a very broad spectrum of activity, way beyond dispute resolution, with currently, I believe, 6 working groups. We are going to just look at dispute resolution as our focus for the coming time. And I want to start by looking way back to a time before any members of this panel had been born, which is 1966. You don't have to comment on that. And the establishment of UNCITRAL itself. Perhaps I can start with Your Excellency, Mr. Abdulaziz. What would you say were the key drivers behind the actual establishment of UNCITRAL in the first place?
شكرا جزيلا توبي، وحياكم الله جميعا وأسعد الله أوقاتكم بكل خير. بداية أتقدم بالشكر للمتحدثين الأفاضل اللي يشاركونا في الجلسة بخبراتهم العميقة، وأرحب بكم جميعا في الرياض في هذا المحفل الدولي المهم. ومثل ما ذكر السيد توبي، نحتفل وسعيدين بالاحتفال بمرور 60 عام على تأسيس لجنة القانون التجاري الدولي الأنسترال، 6 عقود من عمل دؤوب لتوحيد قواعد التجارة الدولية وبناء جسور الثقة بين الأمم وتعزيز سيادة القانون في العالم. فحقيقة ما حققه الأنسترال في هذه المدة والرحلة الطويلة يستحق كل التقدير والاحترام، ونتطلع إن شاء الله ونطمح إلى 60 عام القادمة بما يستوجب إن شاء الله منا جميعا كل جهد وعزيمة. وعودة على السؤال، أعتقد منتصف الستينات لما تأسست هذه اللجنة كان العالم في ذاك الوقت يشهد تحولات عميقة، والتجارة الدولية كانت تواجه تحديات وعقبات قانونية جسيمة. كل دولة لديها نظامها الخاص، العقود التجارية عبر الحدود محفوفة بالمخاطر والغموض، وتنفيذ الأحكام والعقود في دولة أخرى كان أمر أشبه بالمستحيل. فأعتقد هناك 3 دوافع رئيسية وراء تأسيس هذه المنظمة. أولها الفجوة الكبيرة بين الدول النامية والدول المتقدمة في ذلك الوقت. فالدول النامية تشعر بأن القواعد القانونية للتجارة الدولية صممت في دول ولمصلحتها، فكانت الحاجة ماسة إلى منصة محايدة داخل الأمم المتحدة لوضع قواعد عادلة تراعي مصالح الجميع. الدافع الثاني التعقيد القانوني الكبير، فكل دولة لديها قانون مختلف للبيع، في النقل، في العقود، والتاجر الذي يريد التعامل مع 10 دول عليه أن يفهم 10 أنظمة قانونية مختلفة، وهذا بلا شك يرفع التكاليف ويقلل الثقة. فالعالم كان بحاجة إلى هذه اللغة القانونية المشتركة. أخيراً يمكن الدافع الملهم هو ما حصل في اتفاقية نيويورك للاعتراف بأحكام التحكيم الأجنبية في عام 1958. فهذه الاتفاقية أثبتت حقيقة أن مختلف الدول يمكنها الاتفاق على قواعد تخدم التجارة حتى لو اختلفت سياسياً. فقد تكون هذا ما دعا إلى إنشاء الأنسترال بهدف واضح، وهو تعزيز التنسيق والتوحيد التدريجي لقانون التجارة الدولية بما يحترم التنوع القانوني والثقافي للدول.
Your Excellency, I'd like to say that I agree with everything you've said, but there's one slight problem we have. I'm very, very grateful for your comments, but you have tested both Anna and Audley and my Arabic, I think, beyond reasonable limits, if I may say. So whilst I ask the organizers to please provide the 3 of us with a translation headset, which would be much appreciated, I'm going to turn that question over to Anna. I'm not going to say, do you agree? I'm going to say instead, from your point of view, what would you say were the key drivers at the time? And can I make the question a little more specific? When UNCITRAL was founded in 1966, there were many organizations that were busy in private international law, UNIDROIT, UNCTAD, the Hague Conference. So what was it about the UN that it felt it was placed to actually move into this field?
Thank you very much, and thank you again to the organizers for having me here and putting me in such good company to discuss UNCITRAL's 60 years and beyond. So it's a very good question, because what did the UN have that was so special that the others didn't? I would start with the New York Convention. Actually, the New York Convention, which is a product of the United Nations and which is one of its most successful international treaties, has been the founding stone of UNCITRAL. And it's really from the UN Convention on Recognition and Enforcement of Foreign Arbitral Awards that the necessity of having within the UN a body that could discuss how to build. We've been hearing a lot about this ecosystem that seems to be the buzzword wherever we discuss international arbitration and its enforcement. It's really about building this ecosystem, and that was something that the UN could do. There was a need for certain legal certainty, and there was a need also for coordination. And really, and that is the interesting part of it, is UNCITRAL's mandate, which at the origin was harmonization and unification of international trade law, had really a focus on coordinating the various agencies, institutions, some over 100 years old, that were dealing with private international law. The reason why, it's because, of course, the UN had a very broad membership. Most of these organizations had a rather narrow membership, And the idea was really to build these bridges into what at that time were newly emerging sovereign countries that were building their legal system, were building their legislation, were entering this multilateral setting, including on international law.
And what would you say were the key problems at the time that was stimulating this? Why was there such a rush for harmonization? What was the position in terms of international trade law?
Well, I think there were a number of issues. One, of course, and obviously, was the problem of mutual recognition and giving legal certainty and legal effect across borders. So what we were working with 60 years ago, and mind you, Toby, I was already born. I was still in kindergarten, but I was already there. We had two major legal systems. We had the common law system and the civil law system. And it was really felt at that time, when the economy was becoming more international, more global, that bridges between these two systems were needed, and that cross-fertilization and other buzzwords that we like in the UN were necessary between these two. So we started out, or UNCITRAL really started out, building bridges between these two systems and harmonizing the way these two systems deal, among others, with dispute resolution. And still today, and we'll possibly talk about it a bit later, we see that there's still differences in the procedure, in the way arbitration is conducted, but we see that the harmonization goal, that was the goal of UNCITRAL at that time, has really been most effective, because now all the legal systems, whether Chinese law or whether common law or whether civil law, or all the different legal systems or Sharia law, have really adopted the harmonized outcomes of UNCITRAL negotiations.
Thank you very much for that. Audley, can I ask you, at the level of generality, because we'll get in a moment to more specifics in terms of specific UNCITRAL texts, when one goes back to look at the genesis of UNCITRAL and its original mandate, there was debate in the original report as to whether that mandate should be about private contracting parties or states and their activities, and quite how far the reach of UNCITRAL should be. What's your sense as to how UNCITRAL is placed in terms of regulating private contracting parties' activity or states' activity? I mean, in some ways it may be not obvious that the UN would want to be involved in the way that private parties contract.
Thank you, Toby. I think it's interesting that the genesis of UNCITRAL and these instruments was really in the middle of the post-war settlement. And there was great respect for international institutions that could bring countries with different histories and traditions together. And I think it was considered that UNCITRAL, and has been proved to be the case, a great convening power to bring people to have discussions. And it followed some years after the New York Convention, a remarkable treaty that recognized the importance of arbitration agreements and arbitration awards. But what was to be done in between? How do we get from an arbitration agreement that's recognized to an arbitration award that is recognized? And I think that's where UNCITRAL played such an important and useful role in providing a harmonized yet flexible set of rules. And at that time, it was probably only a state-sponsored organization. It was not that there were no arbitration rules. ICC had rules from 1922-23, but they were not as widespread as we know today. Obviously, but not as generally accepted. And I think the state did have an important role, but it was not necessarily thought at that time that the state would be such an active player in commerce, that state-owned enterprises would be as active as they are, and that the blurring between the role of the state as state and the role of state as being active in the business world. And therefore, it does seem questionable as to why the state would be bothered in commerce. But I think it was felt, particularly post-war, that increased international commerce would bring prosperity and peace, and therefore states around the world were very interested in promoting that, and having effective and trusted dispute resolution was a way of doing that.
Anna, can I ask you to set the scene a little bit more before we get to the specific texts? For those who have not had the extreme pleasure of sitting in the UNCITRAL working group sessions, can you tell us a little bit about how UNCITRAL works in terms of its composition and its working practices, and in particular the way in which it uses consensus as a way forward?
Thank you very much. So indeed, UNCITRAL is an intergovernmental body. So the members of UNCITRAL are the states. We have currently 70 member states. In practice, we don't make a difference between member states and non-member states. So every state that is a member of the United Nations is perfectly invited and allowed to participate in UNCITRAL deliberations. It's simply a seating order that changes, and as Toby said, because we are working by consensus and there is no voting, or only on very, very rare occasions, there is a perfect mixture of states, member states, and non-member states participating in UNCITRAL's deliberations. What makes UNCITRAL a bit specific, though, in its way of working, is that we equally open our doors to what we call observers. And we have observers from international organizations. You named, for example, UNCTAD, or UNIDROIT, or the Hague Conference, or the OECD, the WTO, the World Bank. So there are a number of international organizations, and I should not forget to mention the ICC, because the ICC is actually the one that brought the negotiation of the New York Convention to the UN. So it was at the request of the ICC, so business coming to the UN to say to states, please set up a treaty that will give force to what we do from the ground up. So they participate and they bring their expertise. But more interestingly, I think for the audience we have here today, is that we also count on the participation of numerous experts, subject matter experts. We have many arbitration institutions, arbitration associations. We have the International Bar Association, the American Bar Association, different organizations that we call in our jargon NGOs, non-governmental organizations, but that bring their expertise into the working groups. And for those of you who have participated in working groups, they're given equal opportunity to intervene, to respond to particular requests that are made by the states in the working group, or simply to participate in the deliberations. The work of UNCITRAL, the way we decide to work on a particular project, and when I say we, I shouldn't say we, actually it's you, it's the member states. We are only the secretariat, so we're only carrying out what our member states ask us to do. But the agenda is basically set by the states. So proposals for the development of new texts in different areas of UNCITRAL's work are brought by states, by the state, the government representatives in UNCITRAL, and they are generally well informed by their own private sector, by their, say, dispute resolution industry, about what is currently a problem, where is there a hurdle, where is there an impediment, could something be done meaningfully at UNCITRAL's level to make, for example, the enforcement of electronic arbitral awards, it's something we might be talking about, easier across the globe. So that is one of the, really, of the characteristics of UNCITRAL, is that we are member-driven, meaning state-driven, but that there is a very strong participation of representatives from the industry. We call it the industry, but it's more the stakeholders of the different texts that are being developed. And the consensus point is really good, because I would say it's one of the strengths of UNCITRAL to work on consensus, to be based on consensus, because it allows the actual inclusion, or you appropriate what you have participated in developing through consensus. Nothing is imposed on you, but it's the consensus that makes it possible for you then, as the Minister of Justice of one country or the other, to enact this law, because it's a product of your contribution to the consensus. As I said, consensus is the way we work. Of course, people say, yeah, you know, consensus, it means that it's endless. It means that it's minimum common denominator. That's not true, in fact, because you can have some very ambitious projects that gather consensus and garner consensus. And I think this is really what I see as a very big advantage of UNCITRAL's working methods.
So one quick follow-up question, and then we'll get to the texts themselves. When you look at the original report that set up UNCITRAL, it was quite clear about the participation of member states and experts. It was less clear about other stakeholders and NGOs. Over the years, the balance has shifted at different times in the working group room between activity of member states, between experts, between NGOs. How has that balance evolved over time?
Well, it's, I think it's quite remarkable to see how a body which, you know, you would say it's the UN, so it's bureaucratic, it's heavy, it's procedural, how flexible we are, in fact, subject matter by subject matter. And in the case of dispute resolution, we've seen early on that the main stakeholders of arbitration, and then we've seen that with mediation, of course, with the Singapore Convention, how they have played an increasingly important role, either because they were sitting on the delegations of the states because of their subject matter knowledge, or because they were sitting as observers and participating actively as observers. And in the last 10 years, almost 10 years that I've been at the helm of the Secretariat, I've really seen different working groups having very different dynamics, being driven almost by stakeholders, and others being more state-driven. We will probably talk about our working group on the reform of investor-to-state dispute resolution. This is clearly driven by the states. Other working groups, for example, Working Group 2 on dispute resolution, there is, I would say, an equal balance. And one where we had a very strong participation of observers and stakeholders was the working group that recently finalized a new convention on negotiable cargo documents. And you can imagine that the transport industry, the shipping industry, the railway industry, that they all had an important stake in the game. And so they were most vocal from the back bench, if I may say. And they were extremely involved also in driving the consensus. So I would say that it's really this flexibility that is adapted to the different projects that we're bringing that the states are bringing to the table that make a good outcome, which is then easier to implement, to adopt, if it's a model law, or to join if it's a convention, or to implement at the state level.
Very, very good. So let's turn to commercial arbitration. Your Excellency, if I can ask you, from perhaps a state perspective, how would you evaluate UNCITRAL's contribution in establishing and regulating, promoting commercial arbitration?
نعم، فيما يتعلق بمساهمة الأنسترال في التحكيم، يعني يمكن التحكيم التجاري اليوم نجده هو العمود الفقري في منازعات التجارة الدولية. إذا نظرنا قبل 60 عام لم يكن التحكيم بهذه الممارسة من الوضوح، وتفتقر إلى المعايير، وتختلف اختلاف كبير من دولة إلى أخرى. فمساهمة الانسترال في تحويل التحكيم إلى نظام احترافي أعتقد كان له دور كبير. يمكن أبرزها المساهمة الأولى في قواعد التحكيم في عام 1976. هذه القواعد التي وضعت مجموعة من الإجراءات المحايدة المجانية التي يمكن تطبيقها في أي مكان في العالم مع أي مؤسسة تحكيمية أو حتى بدون مؤسسة. فهذه القواعد كانت مرنة بشكل يكفي لتناسب الجميع، ودقيقة بما يعني يوفر الحماية اللازمة. سرعان ما أصبحت هي معيار اعتمدتها اليوم مؤسسات تحكيم عالمية، ونجدها اليوم تستخدم في العديد من القضايا السنوية. ثاني المساهمات يمكن وهو الأهم، القانون النموذجي للتحكيم التجاري الدولي في عام 1985. حقيقة كان نقلة وفلسفة متكاملة للتحكيم، أرسى مبادئ أساسية في استقلالية المحكمين، في التدخل القضائي المحدود، في الدعم القضائي عند الضرورة، وما جرى عليه من تعديل في عام 2006 لمواكبة الثورة التقنية في السماح بالتوقيعات الإلكترونية والإجراءات عبر الإنترنت. ونلمس هذا المساهمات حقيقة في المملكة لما حدثت المملكة قانون التحكيم ونظام التحكيم السعودي بما يتواكب مع القانون الاسترشادي. بحمد الله تم ملاحظة نمو كبير في إجراءات التحكيم، وما أشار له معالي وزير العدل في جلسته الصباحية اليوم. فقط السنة هذه عن العام الماضي زيادة فاقت 40% في طلبات التحكيم، تعكس حجم النمو في هذا القطاع. يمكن آخر المساهمات اللي أعتقد أنها أيضا ما زالت مستمرة من قبل الانسترال في الأدوات التكميلية، الإرشادات تنظيم إجراءات التحكيم في عام 2016، قواعد التحكيم المعجل في عام 21، قاعدة بيانات كلاود التي تجمع الأحكام والقرارات من مختلف الدول لنشر الممارسات الفضلى. أعتقد كان لها دور كبير في تطوير التحكيم ما بين الدول وتوحيد لغة مشتركة في هذا الخصوص.
Thank you very much. That was a very helpful survey of all the instruments in this area in commercial arbitration. Audley, can I put to you the following? UNCITRAL has been responsible through the text that His Excellency has described for the architecture of modern commercial arbitration. There are people who say that what it's done is set in stone what may be essentially a US English, Anglo-US style of arbitration rather than a civil law style. Is that a fair comment? And if not, why not? And perhaps I can just add on to that. How come it's been so successful, notwithstanding that criticism?
I would answer that by saying yes and no, and it depends. And in some respects, it's a Western. I would make it wider than Anglo-American and include Europe, in the sense that it's Anglo-American in that it's quite, the premise is adversarial. It's not explicitly so, but it provides for an independent and impartial arbitrator or tribunal. But it also, for example, states that each side shall have a full opportunity to present its case, which may seem or assume an adversarial style, which then leads to an award. It doesn't say anything about tribunals being inquisitorial. And perhaps if it did, it would mandate that. I would say that the rules and the law are sufficiently flexible that tribunals can adopt that approach, but very rarely do. It says nothing about arb med arb. It says nothing about arbitrators providing a non-binding view during the proceedings. And some civilian lawyers would say, well, that was very important in our system. There was a great number of discussions at conferences that we remember that our German colleagues thought that that was an important part of their domestic system. So I think it is easy to see that it is Anglo-American in that sense, but it needn't be. But perhaps why it has become so is a combination of English being the lingua franca, and therefore people are looking at Anglo-American ways of conducting the law. They have looked at how deals are financed, and it's often Anglo-American banks, and the proliferation of Anglo-American law firms around the world advising clients that will have had their influence. And also the increase in number of arbitrators, in the sense that having the experience tends in very big transactions to take one to Anglo-American law firms, and then through that, if there is a dispute, to the litigation arbitration lawyers as well.
And why is it, do you think, that the model law has had such an impact? I mean, an impact beyond countries that have actually adopted it. I speak from one of those where it's had a sort of pervading, sometimes called a radiant effect, even when it's not adopted.
Because I think businesses want predictability. And there are ways that the model law and the rules can be improved and updated, and they have been. But they want predictability, and I think for states to look at those that have gone before them that have adopted the model law and seen that it's working and it has general acceptability, and think, why reinvent the wheel? Now, some jurisdictions, such as England, with a very long tradition of arbitration and being a centre for commodity arbitration, etc., have thought that they needed, perhaps one might say, a more detailed and more nuanced piece of legislation. But for many, many countries, the model law that you can just go in and take off the shelf and say, this works and will work for us, and we know that there's going to be a commonality of an interpretation and application, is very, very attractive. In the same way that it's almost like an operating system for dispute resolution. There are different ways, but we know that Apple iOS is everywhere, and people are happy with that because they can pick up their phone and use their phones and use their tablets and take it around the world. Why has Windows been so successful for Microsoft? Because once it gets traction and develops and people see it works, why not use that? Why create something new? Others do, but one has to think very carefully, and I think states find that attractive.
And just to pick up one further point from His Excellency's comments, His Excellency mentioned the clout database and the UNCITRAL work to make sure that texts are kept up to date and alive and develop in a consistent way. From your perspective, perhaps with ICA's activity in this area of keeping texts updated, how do you see that? What's the importance of that?
I think the importance is predictability. And lawyers, and perhaps more Anglo-American lawyers, always look at precedent and try to find some case that supports them, rather than just looking primarily at the text. And I think the database of decisions is very helpful for both those with that tradition and those with civilian or other legal system traditions, that there is this pretty much single text. I know some jurisdictions add on, for example, New Zealand added something on confidentiality, but that they can see how other judges, and whilst there's a sort of degree of reluctance for judges to go outside their own jurisdiction for information, not for precedent, but this database is very useful, and I think it is in one nature, when one is dealing with a common text, to at least look at how other respected judicial officers have interpreted and applied it, or how strong arbitration tribunals have implemented the rules, and to think very seriously whether to follow that or not. So I think it's an invariable exercise, and I think taking us back to the New York Convention, it is a single text of 150 states, and for predictability, it's sensible that it can be interpreted, the main provisions are interpreted. Public policy is often the public policy of that state, not necessarily international public policy of a more global dimension. But those judges who may be less familiar with the New York Convention, it's important that they know the sources that they can look to for interpretation outside their own jurisdiction. And for example, ICA has a judicial roadshow. Tomorrow we're meeting with many judges of the 22 states in the Arab League with that judicial roadshow to tell them about how the New York Convention has been interpreted and where they can look if they have a case that requires them to interpret the New York Convention.
Let's switch now to mediation. If I can ask Your Excellency, the points that have come out in terms of commercial arbitration, to what extent do they also relate to UNCITRAL's impact on mediation?
نعم، أعتقد أن الوساطة لا تقل عما تم يعني العمل فيه في مجال التحكيم. الوساطة اليوم ما في شك تعتبر من أنجع الوسائل لحل المنازعات، لكن رحلتها حقيقة من ممارسة غير رسمية إلى نظام قانوني معترف به عالمية كان له يعني دور كبير في جهود الأنسترال قديما في عام 1980 في ابتداء بقواعد التوفيق. الوساطة يعني تحولت إلى علم أو مهنة بمثل هذه القواعد التي وضعت إطار إجرائي واضح في كيفية بداية الوساطة واختياره وواجباته وحماية السرية. ثم أتى بعدها القانون النموذجي للوساطة التجارية في عام 2002. أعتقد هذا حول الوساطة من يعني ممارسة اختيارية إلى آلية قانونية معترف بها رسميا. القانون ضمن الاعتراف القانوني بهذه الاتفاقيات، حماية السرية الكاملة للوسطاء والأطراف، وحصانة كذلك الوسطاء في المسؤولية. كل هذه أسهمت حقيقة في تطوير الاعتراف باتفاقيات الوساطة. وأخيرا ما حدث في اتفاقية سنغافورة في عام 2018 لما حدث القانون التجاري الدولي بشكل جذري ووحد المصطلحات ووضح التعاريف وحسن التفاعل ما بين كافة النصوص الأخرى للأنسترال. أعتقد ما كان يحتاج لها الوساطة هي مثل اتفاقية نيويورك للتحكيم، وهذا ما أتت به اتفاقية سنغافورة للوساطة التي يعني اليوم نعتقد أنها انتقلت من فن إلى مهنة منظمة يعترف بها القانون ويحميها ويمكن تنفيذها ما بين الدول في الاتفاقيات العابرة للحدود.
Many thanks. Now let's switch gear. We know that the original report that set up UNCITRAL said in terms that it was not concerned with states and their activity or with treaties. It was more about private law and international trade. We then are faced with investor-state disputes. And Anna, I want to ask you, what pressure, you might think this is a leading question, what pressure, if any, has that put on UNCITRAL as an organization, and in particular looking firstly at its working methods?
Well, the short answer is a lot. The longer answer is that UNCITRAL wasn't at its first attempt in working on matters that come closer to states and to, I would say, public international law in that sense. We had the Mauritius Convention that was negotiated in UNCITRAL with the clear purpose of complementing international arbitration when states were involved by a necessary degree of transparency to ensure that stakeholders would be aware of what was going on, that stakeholders would have a possibility of intervening, and that the outcome of these awards that were basically coming out of the taxpayer's pocket could be publicized and could be known or accessed by said taxpayers. And so this was, I would say, a first go by Ancitral at this matter that is both, you could say, very close to Ancitral and Ancitral's mandate, because investor-to-state dispute resolution has been patterned on commercial arbitration, and arbitration, which is the most used method of settling these investor-state disputes, is part and parcel of the arbitration ecosystem, to the extent that the Ancitral arbitration rules are often used and referred to in investment treaties and investment disputes. So it was not totally alien to Ancitral to enter into those matters. We have other areas of our work where we touch upon government procedures. For example, we have laws, we have a model law on public procurement, we have a model law on public-private partnerships, and these are typically commitments by the state. So it wasn't alien to look at the state putting up a cap of an economic actor and entering into an arbitration agreement through a treaty or through a contract. So, but when you say what pressure did it put on Ancitral, it put a lot of pressure in the sense that investor-state dispute resolution was a very hot topic. When it came to Ancitral, it was hotly contested, hotly criticized, and to the extent that countries had decided to walk out of this system, or others had said, tabula rasa, we don't want any arbitration anymore, we just want to have a court established. And it's with this idea in mind that the European Union and European countries came to Ancitral saying, this is a place where we can reform investor-to-state dispute resolution in depth by establishing a court and an appeal system. So it came to us with lots of challenges, with a lot of scrutiny, with a heavy participation from stakeholders, but not experts in the matter, but stakeholders representing civil society, which is something that the UN is well aware and well equipped for, but that Ancitral wasn't really well equipped for. So we had many, many NGOs, which are more development or human rights NGOs, coming to Ancitral and wondering about this body and the way it was working and how they would find their place in it. So I think you're right, it was a lot of expectation. I think we have so far, and we are really very, very close to the final stages with the bigger building blocks, but it has so far been quite a positive journey. It's not easy, but it's been so far a positive journey in making sure that all the stakeholders continue to be engaged and work with the states in finding solutions.
So just as we now edge into the more controversial areas, we are almost out of time, and we are now the single obstacle between everybody and lunch. So I'm going to ask for very short answers to some very difficult questions. Your Excellency, how well equipped do you think Ancitral is to address the crisis of confidence with respect to investor-state arbitration?
نعم، حقيقة ما في شك مثل ما ذكرت السيدة آنا، اليوم تسوية منازعات الاستثمار بين الدول ما تعرف بالISDS تواجه حقيقة أزمة ثقة، والدول والمجتمع المدني والأكاديميين يطرحون أسئلة صعبة في هل النظام عادل، وهل هو منصف، وهل يحمي المصلحة العامة، وهل يعامل الدول الغنية والفقيرة بإنصاف. انتقادات بشأن الشفافية والاتساق والتكلفة الكبيرة وتضارب المصالح ما في شك كلها تستحق الاهتمام. فيما يتعلق بما يمكن أن تساهم به الأنسترال، أعتقد أنها ما زالت مساهمة محورية أن تعالج في هذه الأزمة. أولا ما تم إصداره في مدونة السلوك في عام 2023 أعتقد أنها وضعت الجرح على أحد أهم أكبر المسائل المتعلقة بتضارب المصالح والانتقادات التي تتوجه أحيانا إلى النادي المغلق من المحكمين والمحامين الذين يعملون كمحامين في قضية ومحكمين في أخرى. أصبحت اليوم بتطبيق هذه المدونة والعمل عليها تحت الرقابة، وتفرض واجبات صارمة للاستقلال والإفصاح وآليات لإنفاذ هذه المعايير. الأمر الثاني يمكن ما تم المركز الاستشاري الذي تم اعتماده من حيث المبدأ في عام 2024. أعتقد أن هذا بيوفر مساعدة يعني قانونية للدول النامية بتكلفة مدعومة أو مجانية، وهذا لعله يخفف من عدم التكافؤ بين الدول والأطراف، وكذلك يحسن جودة الدفاع. أخيراً الحوار المفتوح اليوم في مجموعة العمل الثالث وما أشارت له أنا حول إصلاح شامل. الحوار حقيقة ليس بسهل، هناك انقسامات بطبيعة الحال، ولكنها حوار ضروري ومهم للوصول إلى هذه الرؤية المشتركة في إصلاح هذا النظام. المساهمة المستقبلية يعني بلا شك الدور على الأنسترال والدول في تطوير هذا النظام بحيث يكون أكثر شمولية وعدالة، نظام يوازن بين حماية المستثمرين وحماية حق الدول في التنظيم لصالح المصلحة العامة، ويضمن استقلالية المحكمين ويمنع تضارب المصالح، بحيث يكون نظام أيضا متاح ومعقول التكلفة لمختلف الدول وليس فقط للأغنياء سواء من المستثمرين أو الدول. وأخيرا نظام يحترم سيادة الدول دون أن يضعف الحماية المشروعة للاستثمارات، فهو تحدي كبير، ولكن بالبناء على ما تم إنجازه ونجاحات عظيمة في الانسترال بإذن الله قادرين على إصلاح هذا النظام.
Thank you very much. I think we are almost out of time, so I'm going to give the last question to give it to Anna, if I may. And that is, we are obviously in a world of geopolitical turbulence and uncertainty. When we all gather together in 60 years' time to celebrate the next big birthday of UNCITRAL, for your diaries, that will be 2086. So please mark it now for RIDU 86 and the 65th SCCA conference. What do you think, looking back at that point, we will be saying about UNCITRAL? Will it have navigated the choppy waters, and will it have survived, and what will it have achieved?
Well, in 60 years from now, I hope I will be up there, floating with my angel wings and having a bird's eyes or angel's eyes view over what's continuing to happen in UNCITRAL. I think that the essence of UNCITRAL, which is this bringing together so many different actors to come up with a unique and harmonious and unified solution, is always going to be necessary. So whether we want to do it at the regional level, as seems to be a trend currently. Yesterday we were talking about the rule of BRICS. We've been talking about these regional trends times and again. The European Union is a good example of wanting to set up its rules and then trying to reach out with its system. But you see that it doesn't work unless there is a common deliberation, common discussion of it, and unless there is this integrating it into your own reality. And I was quite inspired by the previous panel where the president of the Council of Experts was mentioning that what is important for him when all these model laws and all these texts come is to look at the international benchmarking and see, okay, where has this already been adopted, where has this worked well, and to be able to bring in its own, the Saudi dimension. And this is what works well in UNCITRAL's text because of the fact that they're sitting at the table. And I think that this is not going to go away, Toby. So hopefully the two of us will be up there and we will watch UNCITRAL continue to thrive. I hope so.
With
Thank
that
you.
note of optimism and confidence, I think I will draw the session to a close. Look forward to seeing everybody in 2086, and I'm sure before that, God willing. I'd like to thank all the members of the panel very much for your very, very interesting contributions, and to thank all the members of the audience for allowing me to delay your lunch. And with that, I wish you all bon appétit. Thank you very much.
Thank you.